speakers?
So I would like to welcome everybody and apologise for the delay in the start of this session, but we've had a few technical difficulties. So my name is Andrew Mitchell and I'm a Professor and Associate Dean for Research at the Monash University Faculty of Law in Melbourne. And my research is focused primarily on areas of international economic law, including trade and investment law. And it's a real pleasure for me to be chairing this session of the 2021 SIEL Global Conference. Now, the issue of global value chains and corporate social responsibility is becoming ever more important as various social issues confronting the international community, such as human rights violations and environmental harm, become increasingly intertwined and influenced by decisions made in domestic and international commerce by private actors and their stakeholders. So I think it's a very exciting session topic that's really been organised for today, and we have a lineup of some excellent speakers. So I believe that Professor Bonfanti will be speaking first. She's an Associate Professor in International Law and Head of Studies of the Master's Program in Sustainable Development at the Law Faculty at the University of Milan. She teaches EU law on business and human rights, sustainable development in global trade, and her research activity chiefly focuses on business and human rights, public and private international law, cyber law, and international trade and investment law. She's also a member of the interest group on international business and human rights of the European Society of International Law, and co-director of the Business and Human Rights Summer School. Our second speaker will be Professor Baghdadi, who is Professor of Economics at ESSEP, University of Tunis, where she holds the World Trade Organization chair. She's an executive board member of the Central Bank of Tunisia and a member of the Tunisian Council of Economic Analysis. She serves as a member of numerous boards and committees, including the advisory board of the Economic Research Forum based in Cairo. And she's an associate editor of the Middle East Development Journal. Our final speaker is Professor Ventoruzzo, who hasn't joined us just yet, but hopefully will in time, who is a full professor of business law and head of the law department at Bocconi University. He was previously Professor of Law at Penn State Law School and Director of the Max Planck Institute, Luxembourg. He's a research associate of ECGI, an attorney specialised in corporate law, and he has served on the boards of several corporations, primarily in the financial sector. At the moment, the plan is for each of our speakers to talk for roughly 10 minutes, and then we'll open up the floor for some questions and a discussion with the panel. And you can see that there's an opportunity to put questions in and also questions in the Q&A. So, Professor Bonfanti, I'll hand it over to you to start us off and talk about your, begin your presentation on human rights in global value chains, challenges and prospects in light of the draft UN Treaty on Business and Human Rights.
Thank you very much, Andrew. So let me just share my presentation. Okay, here I am. So do you see it? Is it fine? Do you hear me? Okay. So first of all, let me thank SIEL for the kind invitation, the Society of International Economic Law for the kind invitation and for the opportunity to talk and to discuss about such a challenging topic with the distinguished speakers involved in this panel. Within my presentation, I will address the negotiation process of the draft treaty on business and human rights, seeking to assess whether the draft treaty represents an effective and useful tool to prevent and remediate the corporate-related human rights violations. So I will start reminding that the negotiation process started in 2014 when the United Nations appointed the open-ended working group with the mandate to negotiate a legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. Since then, the working group has elaborated 3 drafts, the last of which dates October 2020 and is a definitively more mature text than the previous drafts. Nonetheless, the treaty still raises criticisms that are worthy of consideration in the context of this presentation. So, which are the most innovative aspects of the treaty? First of all, the future treaty, the draft treaty, provides for both public and private international law obligations on the contracting states. And most innovative substantive obligations it sets are, respectively, the provision for the state obligation to introduce at the domestic level the so-called human rights due diligence duty on corporations, and the obligation for the contracting parties to grant that victims of corporate-related human rights violations can have an effective access to remedies. To this last regard, the treaty establishes uniform criteria of jurisdiction and applicable law that are decisively favorable for victims of corporate-related human rights violations to file claims and establish proceedings. And therefore, it might be suitable to make access to remedies easier and more effective. Now, coming to the critiques. Some detractors complain that the treaty is not exhaustive. Now, the non-exhaustiveness of a treaty is something inherent to treaty law, so I don't think this is really a problem. The treaty provides with details an international obligation on states to protect human rights from inter-private violations, including corporate violations. And so the positive effects of the treaty is to provide with details these international obligations by establishing specific processes and criteria that might fill with content, with specific content, these international obligations. But nonetheless, the treaty will be necessarily interpreted and implemented in light and through the others international law provisions. So no problem with the lack of exhaustiveness. And again, someone criticizes the treaty for the limited field of application. The treaty instead will cover not only the activities and the wrongdoings occurring within the activities of the transnational corporations, as it was foreseen at the beginning, but when Ecuador required the institution of the working group, but progressively the treaty has been extended to cover also the activities of the other business enterprises with that undertake business activities of a transnational character. So it seems to me that the field of application has been progressively extended as to cover the most risky fields. Instead, I agree with the critique that the treaty has a weak enforcement mechanism in place. In fact, the treaty provides for the establishment of a monitoring committee that that is charged with the task of receiving and reviewing the periodic reports submitted by states, but has not, and instead has not the task to receive individual communications against the state, for instance. And there is no mechanism for the filing of individual communications against corporations. So this might be a shortcoming of the treaty. Now, coming to the global value chains, I would like to underline that the treaty obligations will extend to the protection of human rights from the corporate activities of the transnational corporations, other business entities with transnational character, including the global value chains. To be precise, the treaty does not use the words global value chains. Instead, it uses the expression business relationship. So the human rights due diligence obligation, for instance, that is a process for which the corporations have to map the risks, the effective and potential risks on human rights arising from their activities, prevent the negative impacts and remediate them. This obligation will cover the activities of the transnational of the corporations and their business relationships. The business relationships includes all the relationships established by the corporation through the affiliates, the subsidiaries, the suppliers, the contractual relationships, and therefore the idea is very connected to the idea of global value chain. There is no link, no reference to the direct business relationship. So the concept is a broad one and seems to include also the indirect relationship. And this is something different from the United Nations Guiding Principles on Business and Human Rights. The guiding principles are the soft law instruments on which the treaty is somehow modeled. They were adopted in 2011. And they paved by the United Nations, and they paved the way to the development of corporate accountability for human rights. And so for the first time, they, for instance, conceptualized the idea of human rights due diligence that is actually ardent within the treaty. Now, the global value chain is also covered through the obligations concerning access to remedies. So the treaty, for instance, establishes that the contracting parties have to grant access to remedies at the domestic level for human rights abuses that may arise from the corporate activities, meaning the own business activities of the corporations established within their territory, including those of the transnational character or from their business relationship. Therefore, again, the obligations covers the global value chain. Now, there are, it seems that global value chains are definitively covered by the treaty, even though there are still gray areas that are not clarified by the draft treaty. For instance, the treaty does not clarify which relationship exists between the compliance of the duty of human rights due diligence by the corporations and their liability in case a negative impact arises nonetheless. So even though the human rights due diligence has been correctly implemented. And the second gray area I see concerns the specific standard of conduct arising from the human rights due diligence duty. So whether it is it entails an obligation of means or an obligation of result, we might discuss later, but some interesting suggestions might be inferred from the recently decided case against Shell by the District Court of The Hague concerning the reduction of the greenhouse emissions, where the court has stretched the distinction between obligation of means and obligation of result arising from the due diligence duty of the parent company. So coming to the conclusions of my presentation, it seems to me that the treaty is a necessary and useful tool to strengthen the corporate accountability of human rights abuses. And in fact, it contributes to the development of the legal concept of corporate responsibility of human rights, moving from the same concept of corporate responsibility of human rights as it was established under the United Nations Guiding Principles, where nonetheless it was a moral concept. And this occurs even though the treaty does not pose directly on corporations any international obligation. The treaty, again, has the positive effect of clarifying once for all the extraterritorial dimension of these obligations, of both the human rights due diligence obligation and of the obligations concerning access to remedies. And therefore, it seems to me that the effect is an overall positive effect. We will see how many countries will ratify it, if ever adopted, and this will be, let's say, the step, the necessary step to make it effective internationally. Thanks.
Well, thank you very much for that excellent presentation, Professor Bonfanti. And now I'm delighted to ask Professor Baghdadi to begin her presentation on the topic of CO2 emissions, environmental provisions, and global value chains in the Middle East and North Africa region.
I hope you can see my presentation. Then first I'm very happy to present today. I come from a different background, which is I'm an economist, then it will be quite different, but I hope it will get your interest. Then we were working with my PhD student actually on this topic on CO2 emissions, environmental provision, and global value chain in MENA countries. The motivation comes from several facts actually. First, we can see that from the latest International Transport Forum edited by the OECD 2017, they show that air pollution coming from international freight transport could increase by 160% by 2050. At the same time, several other work, actually my old work with other co-authors, we show that some trade agreement with environmental provision, and specifically NAFTA, before changing its name, actually reduced emission of pollutant by 2/3 in the United States. And a third thing, which is the pollution heaven hypothesis, where CO2 emissions were shifted from developing countries to developing countries because of the lack of environmental regulation in developing countries. And something else really increased my motivation and the motivation of the group we're working with. It is our own experience in Tunisia, and working as a member of the Council of Economic Advisors. We are working on a deal to increase to help Tunisia upgrade its global value chain and increase its participation in global value chain, we found that actually it is not working. When we're working in developing this deal with syndicate, with trade unions in the country, we received a lot of questions and doubt about environmental regulation in the country, social standards, decent working. And if you're only linking or thinking about economic efficiency, it will never work at the local level with firms in the country because of the various criticism of the different social actors and workers themselves concerning their health status, decent work, etc. Then all this really, we begin from before this paper, and we continued with this paper to really look into global value chain. And we are here talking specifically about how the participation in global value chain, and differently by sector, by type of sector, by type of participation, will impact bilateral CO2 emission. And we're focusing on in the MENA region, Middle East and North African region. And here we also specifically explored the impact of regional trade agreement with environmental or without environmental provision on bilateral CO2 emissions of two countries. Then it comes on the academic literature. We have several strands of literature. Then there are some papers that look into the environmental effect of trade openness. With generally now we are coming to kind of consensus of the overall negative impact of trade openness and FDI, for instance, on air pollution. Recently, very recent papers on the impact of international trade in intermediate products, which is also a way to approximate for global value chain on emission in developing countries. New strand of papers highlighted the importance of trade agreement with environmental provision. For instance, a paper I did in 2013 with other co-authors, we show that actually RTA's regional trade agreement with environmental provision decreased or helped to convert CO2 emissions of two partner countries. But still, we still don't have enough paper on GVC, on the interlinkages between CO2 emission and GVC. And that's what we want to do here in this paper. Then concerning GVC, what we have three channels, let's say, maybe more, but here let's just speak about these three channels. First, participation in GVC could benefit country because of efficiency effect, let's say. Efficiency from what we call here in the economic jargon, composition and technique effects, the fact that we can access to technologies, eco-friendly product, it can lower the cost of the use of new technologies. But there is what we call scale effect, which drives early stage participation in GVC, and this could increase per capita carbon emission. Then the particularity of global value chain that a good will cross a border several times. Then pollution coming from transport will be higher in GVC. And third, we have also the pollution having analysis, which is even more present in GVC than a normal trade, where you have migration of industries in countries with weak environmental protection, which becomes a major concern in GVC. And this was, for instance, something I lived through construction of a deal in GVC at the country level in Tunisia. Then this paper, basically, it's an empirical paper where we want to explain bilateral emission of CO2 embodied in trade between two countries, countries in the MENA region. These are the country emitter of CO2, and countries in the MENA and outside the MENA. And we want to explain that by the type of participation in GVC, Is it forward? Is it backward? The type of sector, are we in the primary sector? If the sector is a primary sector, for instance, agriculture, mining, carrying, or high-tech manufacturing sector or low-tech manufacturing sector. And then we want to see also if RTAs with environmental provision or without environmental provision will impact differently the bilateral CO2 emission. I will not present the empirical methodology. I'll just explain what we mean by backward GVC participation. It's when a country import a product, will transform it and send it again to another country. Forward GVC participation when domestic content is exported to a partner country, and this partner country will export it again to a third party. Here we'll look to backward GVC participation for 3 different sectors: primary sector, high-tech sector, and low-tech sector, and we do the same for forward GVC participation. We'll use a workhorse model, use it in this empirical literature, which is the gravity model for the period 1995-2015, and we are using a battery of variables which are particular to this kind of literature than bilateral variable like if the countries, the distance, for instance, bilateral distance between 2 countries, if they share the same language, etc. But the most important thing will explain bilateral CO2 emission by backward or forward participation of the emitter country of CO2 in these 3 different sectors. If both countries are part of a regional trade agreement with environmental provision or without environmental provision, and how this will impact the bilateral CO2 emission. We also take into account not the rule of law, but the quality of institution in the country. Then what we find, I will jump directly to our results, we found that actually regional trade agreement increase carbon emissions for all different type of participation, either in backward or forward or in the different sector. However, RTAs with environmental provision could reduce carbon emission, bilateral carbon emission in emitter MENA region, MENA countries, in forward low-tech manufacturing, for instance, textile, it is in low-tech manufacturing sectors, and in backward low-tech manufacturing sectors and primary sectors. We found that good governance of institutions in the MENA region decrease carbon footprint overall. It is very important to look when we think about CO2 emission and we are thinking about regional trade agreement. It's important to take into consideration what kind of participation in global value chain the country is involved in, because it differs quietly, actually, in at least empirically using data. It differs the kind of sector the country participates in and the kind of GVC participation could impact CO2 emission very differently. And since environmental provision are important quantitatively, at least, it seems to be important to think as efficient tool, maybe, to consider to reduce bilateral CO2 emission. Then again, globally, we found that environment suffered deterioration when MENA countries engage in forward low-tech manufacturing sector and backward high-tech manufacturing sector and primary sector. It's important to think about environmental policies at the local level, but again, regional trade agreement with environmental provision are important to consider as a tool. Then what is also important to think that we need also an incentive mechanism to upgrade in the value chain and think about ways that developing countries, for instance, will not take environmental provision as another way to increase their cost of exporting and upgrading, will become a barrier to trade. Then it's important also to think about an incentive mechanism for firms to upgrade and not taking it as an additional burden. Thank you. I'll stop here.
Well, thank you very much for that excellent presentation, Professor Baghdadi. And last but certainly not least, Professor Ventoruzzo, I would be grateful to hear from you and your presentation on corporate purpose, ESG, and actual civil liabilities. Thank you.
Thank you. Well, given the time we have, I will just focus very briefly on the proposal of directive on corporate due diligence and accountability. Again, the time limit forces me to be a little bit, let me say, brusque. But I think this is an awful piece of legislation. It's very poorly conceived, written, and executed. I do think that some of the ultimate goals are obviously enough desirable, but I think it shows a lack of procedure, knowledge and understanding of how business work, and also is somehow, allow me to say, from the point of view of the politicians, and in fact it starts in the parliament, a kind of populist tendency which fits understandably and nicely in a certain movement, but I think in this particular case, again, it's somehow poorly executed. Let me just give a few examples among the many that could be given, and of course, let me also premise, I understand that it's project, first of all. I understand it's a directive, so this does not rule out the possibility of, not only improving it, or as I would suggest it, scratch it and rewrite it, but also it might allow to, correct it, to have additional pieces of legislation, either at the EU level or at the national level, that might somehow specify and correct the things that have been written here. But still, the name of the game, I guess, is to be a little bit provocative, and so let me do that. The kind of duties that are or would like to be imposed on corporations in this respect is extraordinarily broad. It's broad, and it's also not entirely clear what should be done. Just to give a few examples, there are these grievance mechanisms that are, very vaguely defined. Needless to say, it can, frankly, sometimes also be a good commercial strategy of a business to do something like that, but to provide it as a specific obligation, of which, once again, it's not entirely clear what are the consequences in case of breach, and how it might fit together with the broader liabilities that are established in this framework. I think it's problematic. But going to the core of the matter, at least from our perspective here, and based on the title of my very brief, talk, civil liabilities. Now, there is a provision, Article 19, which once again establishes an extraordinarily broad potential scope of liability under a number of criteria and dimensions. First of all, the very kind of obligations that could be breached are not clearly defined. What does it mean? And I know I'm simplifying. I know that my more learned colleagues that are more versed in the international treaties on this matter that are referred to might help, obviously, fill in the blanks. But generally speaking, it's I think fair to say that it's unclear what it means not to cause prejudice to human rights and the environment and good governance, not even potentially. And most of all, either we are talking about specific and additional obligations currently that cannot be found in the different jurisdictions, or not. I do believe that the vast majority of the violations of, I think, human rights, also the ones that might be concretely relevant in terms of the environment, would already, in one way or in another, either represent a tort or the violation of specific regulations, as in many ways the Shell case that was mentioned before supports. In the Netherlands, they didn't need this to achieve a quite, we could discuss whether it's desirable or not, whether it's, but so the first question that comes to mind is, of course, how broad and to what extent there are additional obligations. The second, of course, has to do with this concept of business relationships and value chain. And again, I'm aware that I'm somehow simplifying, but I do believe that we are getting very close to it, some kind of vicarious liability for facts and actions of third parties, on which, frankly, in a lot of situations, the reality is that even adopting a very good and high level of diligence, a business can have very limited control. There's a bunch of other things that I could refer to. Let me just say a couple of things and then I will stop here. One is irresistible to me. Article 19 explicitly says that the corporation can be held liable and has to provide a remediation for any harm arising out of potential or actual adverse impacts. Now, the notion of harm arising out of potential impacts is quite funny to me. But again, that's probably just a mistake, but that somehow indicates how this has been drafted. In terms of potential plaintiffs, extraordinarily broad once again. And I will not venture into a territory that I'm less familiar with, but my understanding is that, taking into account both the fact that these are explicitly indicated as mandatory provisions, both in terms of jurisdictions, applicable law, and so forth, you basically would have an potentially extremely aggressive approach to jurisdiction. Frankly, even more aggressive than the US one. That, in the US, we all know that that there was, at least traditionally, a quite open doors to even foreign cubed litigation. And again, I think that is a problem. Also considering the fact that, as we know, this directive affects also corporations, enterprises, and groups that are not particularly big. Now, long story short, and I'm aware that in this period, whenever you come off as sounding even slightly critical of anything that has in its word environment, human rights, you might be accused of being this kind of ugly capitalist that wants to protect enterprises, but I can assure you that it's not the case. I really just think that it's technically very poorly written. But if we want to fly a little bit higher, I also do have one underlying question. I'm more than happy to think that businesses and enterprises become more socially responsible. I think there's a number of things that have been done, should be done, and could be done to create incentives, and in some cases, even possible consequences if they don't. What I'm a little bit perplexed about is, one, that there's a little bit the tendency, and maybe I'm speaking here more to the economists, among us to delegate, in a way, the production of, if not public goods, semi-public goods to private enterprises. And I think that that is always, you know, a little bit difficult and a little bit dangerous also politically and socially. Because to some extent, there is a little bit, once again, the idea, you know, of think about the whole debate of corporate purpose. No, oh, corporations should write in their bylaws that they are, you know, consider the long-term benefits of all stakeholders without having even defined exactly what stakeholders are. And you know, of course, if you want to be cynical, that's the oldest trick in the hat. You know, the business themselves, they say, you know what, you know, legislator, regulator, we are so good, we will take care of this. You know, we will put in our bylaws that we are good guys. And it's not surprising that among the staunchest supporters of corporate purpose, sustainability, there's you know, the Business Roundtable, Davos. Okay, so I've nothing against those organizations, but to the ones that might think that I'm kind of criticizing this from the right, in a way, it's more a critique from the left, if you want. So this idea that the state somehow delegates through empty and very broad liability provisions, requests that businesses follow vague and ambiguous goals, such as the ones that I've mentioned before, I think it's a little bit of a step back, or might be in reality a step back from the much harder work of regulating things, saying what could and could not be done more precisely, which gives also guidance to business. Let's not forget that those kind of regulations are also a formidable anti-competitive tool against smaller business. And sometimes I wonder whether among the stakeholders protected there are, which would make me happy, as I, you know, also sometimes dirty my hands with practicing law, lawyers more than workers in India or wherever. But I will stop here and thank you.
Well, thank you very much, Professor Ventoruzzo. That was a terrific presentation. So we've had three very provocative and interesting presentations, and we already have one question in the public chat, and there's also an option to post your questions on the Q&A. In the public chat is for Professor Bonfanti, who says, it's a pleasure watching you deliver a presentation after a long break. I was wondering if you think there are some inspirations in the UN treaty process that you can draw from the EU due diligence draft directive in terms of penalties for non-compliance with due diligence requirements. The latter is an ambitious text in this respect. If in the affirmative, do you think that a stronger due diligence provision could reduce the political willingness to adopt a treaty at the UN level?
The treaty and the European Parliament resolutions, the draft treaty and the European Parliament resolutions are clearly different tools. And so even though I share the critique by Professor Ventoruzzo that the directive is not, I mean, it shows gray areas, but it's part of the job of the directives. I also think I see that the directive is more detailed than the treaty, and so I think that some, that the treaty might also include some of the interesting tools included by the directive. As concerns the sanctions, for instance, actually, also the treaty provides for the sanctions that states should establish in their domestic legal systems in case the human rights due diligence obligation is not fulfilled by corporations, and the remedies so that access to remedies, another tool that seems to be put on the table with the same respect. Yes, I think there can be cross interactions, and I also think that there might be cross interactions on the opposite side, because, for instance, the treaty, and we can discuss whether the criteria selected are the most effective ones, but the treaty, for instance, includes a private international law section where it lists criteria on jurisdiction and applicable law that instead the directive, the European Parliament proposal as it is nowadays, as it has been adopted, does not include. I just would like to remind that the draft of the European Parliament resolution did provide for a private international law section where the Rome II under which the Rome II regulation and the Basel I regulation should have been amended as to include more favorable criteria for victims of business related human rights violations. And the criteria that were proposed by the European Parliament resolutions are quite similar to the ones today included within the draft treaty. Nonetheless, at the end, the European Parliament proposal was adopted with the deletion of that part on private international law. The only provision that the European Parliament resolution includes on this topic is the reference to the fact that the provisions will be considered as internationally mandatory provisions. Therefore, yes, at the end, the treaty could learn from the directive, and the directive could learn from the treaty. So mutual exchange would be desirable from my point of view.
Thank you very much. We also have a comment from Professor Seradotti, who says, thanks to all the very interesting and provocative presentations, and says that I think the real issue is responsibility of enterprises for the conduct of the foreign independent supplier. What if the latter comply with less stringent local regulations? Is a due diligence standard practicable and satisfactory? Anti-corruption has evidence to this approach, and I'd invite anyone in the panel to respond.
If I may, yes, I agree. That's one of the examples. The way I read it, there's no question that if you have a supplier in a far-fetched place, and it turns out that while respecting their own local rules, and let's look at the environment, because I think if you look at human rights, and again, apologies for being somehow simplistic, again, violations of human rights are so self-evidently horrendous that it's a little bit harder to assess it. It has it almost seems to have a less technical aspect. But if you look at the environment, without discounting the relevance of environmental problems, but we can all, I think, agree that at the regulatory level, there might be some different ways to do certain things. Now, my sense is that in principle, at least, based on what Giorgio is saying, you could have a supplier that is in compliance with local rules, but because it does not fit with the standards, which I posit are not very crystal clear, that might derive from these agreements, you might end up being sued in France, in Belgium, in the Netherlands by, let's say, the local community over there. And I think that that is something that should be considered seriously.
To respond?
Leila, would you like to answer?
Yeah, but I'm not sure I will answer totally the comment, but I think again, from what we have been reading and our experience here, first, the regulations are very low, less stringent, clearly, and they're not even up to the local debate in what you call far-fetched countries. In the public debate, there is really a divide between what the population perceive as environmental regulate, what they want to have, and what is really practice it. Then there is a way, actually, when there is a debate in international regulation or agreements, it could upgrade a little bit, or can put pressure somehow to really respect some due diligence. And maybe in a backward, when you are in global value chain, you have to respect some standard. They have been, for instance, for the, what we're calling it here, high-tech manufacturing. It's not always high-tech manufacturing. Electrical machinery, they have standards. Then a firm in a local contract should absolutely respect. Otherwise, they are outside from the chain. Then we could think that this environmental regulation should also hold for every step in the chain. There are some there is also, that's why I'm speaking, not only rules, but also incentive mechanism. And here the finance world could also be a good force to force these people, the local contractor, to respect some environmental regulation. Then we are speaking about ESG, we are speaking about investment funds that are, they will give funds if, some metrics are held. We are now looking to the look of the production of firms, and there are a battery of indicators maybe we should think about. They will never be totally efficient, but still there are some mechanisms that we need to think about, and not only regulatory, which is extremely important, but also thinking about incentive mechanism like coming from finance and other ways.
Can I add some words? Thanks. Yes, Professor Sacerdoti, I see the same critical issue that concerns the contractual suppliers. And I think this is the most innovative part of the framework. That doesn't mean that the standard of conduct will be the same when dealing when the wrongdoings occur within the subsidiary companies or within the contractual partners. I don't know whether this will be the final and practical solution, but for instance, if we take the shared decision I was mentioning before, that the court has clarified that, for instance, the due diligence obligation of the parent company over the corporate group, meaning the subsidiary companies, an obligation of result, while the obligation is an obligation of efforts if they look at if the contractual suppliers are concerned. So when the contractual suppliers are concerned. So it seems to me that the standard of conduct can be differently shaped depending on the specific entities included within the business relationship. If I may, I thank you very much, Professor Ventoruzzo, for the critical points he has raised on the human rights due diligence, and I see that from the corporate law, and this is very necessary, in fact, to discuss about together from the international law and corporate law, because we have really different skills and competencies on that. But I mean, from my perspective, that is an international lawyer perspective, so I move from different backgrounds. My impression is that, for instance, the last point you have raised on the delegation to private entities of the role to protect human rights it's a critical point, but the delegation is not to protect the human rights. It is just the reminder that corporations must respect human rights. So from the very human rights legal theory, I would say that what corporations are required to do is to respect human rights, while states are still obviously the primary duty bearers of the responsibility to protect human rights, part of which is the implementation of these pieces of legislation. And so I agree with you instead on the incentives that might be very welcome. I see the problem with the potential effects. So that seems to me very connected with the idea of human rights impact assessment and the preventive, the preventive effect of these pieces of legislation that is part of the reason why they have been, respected. So yes, we move from different perspectives, and I'm in support of this. So I'm less critical than you on these points. Thanks.
Well, thank you very much. At the moment, we don't have any questions from the public. I'd encourage you to please put any questions you have in the public chat or in the Q&A section. But my position as chair to pose some questions very much from the perspective of an ignorant outsider. And I might start with Professor Bonfanti, please. I wonder how you think international instruments such as the draft UN Treaty on Human Rights can best be incorporated into trade and investment agreements, whether in multilateral agreements at the WTO or between smaller groups of countries. And if they can't be incorporated, how can or should these commitments be aligned with trade?
Thank you very much, Andrew, for the question. The issue of the interaction between trade and investment agreements on the one hand and the new business and human rights future treaty on the other hand is a tricky one, actually. The new treaty, so the draft treaty, includes a coordination clause with the existing investment and trade agreements, according to which these agreements should be interpreted and applied in such a manner as not to disregard the newly established obligations from the business and human rights treaty, let's call it. While as far as the new treaty, investment and trade agreements are concerned, the draft treaty includes a supremacy clause, let's say, so establishes that the new treaty will necessarily have to be in line with the business and human rights treaty itself, so with the obligations established by the draft treaty itself, and with the human rights obligations established by other human rights treaties. And this last part of the clause is, in my opinion, a problematic concept, as it might be difficult to apply, but not only from the practical point of view, but also could involve problematic aspects as concerns the effect of the clause itself on the third parties. So this from the perspective of the new treaty, while as from the perspective of the new investment or the investment and trade agreements, there is a trend concerning the progressive implementation and integration of human rights, environmental standards, corporate social responsibility standards that could benefit of the establishment of binding obligations, of detailed binding obligations on this topic. So also when interpreting the existing treaty, when deciding disputes in the investment and trade fields, the fact that there are binding standards in place might be helpful in order to make international law less fragmented. So thanks.
Thank you very much. And I might ask a question to Professor Ventoruzzo, if that's all right. If directors and companies are subject to duties that are owed to a broader cohort of both shareholders and stakeholders, how can a company best juggle the interests of not just shareholders vis-a-vis stakeholders, but also conflicting interests belonging to different stakeholders? And is there a way that companies can mould a corporate purpose that adequately balances conflicting social and corporate values?
You know, thank you for the question. Corporations and businesses have been doing that since, you know, at minimum the Middle Ages. There are these 15th centuries treatises on merchants giving suggestions to younger merchants and saying that, you know, they need to treat nicely their apprentices and employees, and the customers should trust them, and the local community and the church and whatnot. You know? So in a way, it's not so surprising, and it's implicit in the fiduciary duties of directors. Now, the one thing that I'm skeptical about is that when you express these corporate purposes, you know, it might have a, let's say, cultural value, a kind of organizational value, but when you think or hope that those might represent a compass for corporate actions, then, you know, the reality is that I believe at the end of the day, they are either useless or dangerous if in the hands of either a supervisor or a judge that wants to get a little bit creative. Now, your question is obviously exactly on point. To balance the interests of the different stakeholders is inherently what defines the power of directors and corporate actors, is inherently the reason why they do not have a specific complete contract governing their obligations, but they have fiduciary duties. So the fact that you explicitly indicate that there are other stakeholders that should be taken into account, so it's, you know, in a way it's all good. As I mentioned, you might say, well, it's obvious. On the other hand, it increases by definition the discretion and the discretionary power of directors. I'm not saying, you know, just to make sure, I had similar critiques also against the formula of maximizing shareholders' value. Also that, you know, we might try to fool as many people as we want, but legally speaking, it means virtually nothing. You know, at the end of the day, you have to consider whether you were negligent given the information, but it doesn't really offer a true solid guide. A moderately decent advocate can easily argue that a lot of very different and profoundly different choices are either in compliance with maximizing shareholders' value or maximizing stakeholder value. So it's all, you know, this kind of narrative that we like to, because we need probably something to discuss about that these are these two completely different words, and Milton Friedman is this ugly, you know, supporter of Ronald Reagan, and now finally we are coming to our senses because we are becoming good people. And sorry, and let me finish here. So, you know, I don't think that there's a way to specifically reconcile this, as you say, conflicting interests of stakeholders. I think it's natural that there is no magic formula. That's the way it should be. That's exactly the job of directors, to figure out, keeping into account primarily the interest of stakeholders in the sense of people that have invested something, not necessarily money in the corporation, but also other stakeholders. They have to balance those off. The attempts to either specify, again, they might have a marketing value, they might have a commercial value, they might have a cultural value, but legally speaking, I think it's limited, and it's right. Look at the UK Companies Act of 2006. They, Section 172 explicitly says shareholders at the statutory level. The director should take into account shareholders, creditors, providers, suppliers, blah, 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 and the community and that. As far as I know, and I would be happy to be corrected, the cases truly based on this provision are, maybe there's one or two that kind of indirectly mention them, but they have not been used by courts to assess liability, and therefore it's hard to consider them a true relevant guideline for directors.
Thank you very much. Can I ask the panelists whether they have any questions for each other that they would like to pose at this stage?
I do for Leila, if you allow me, since we have an economist. Again, I do understand it's forced somehow to say, and also just to specify with Angelica, who is right. I'm not saying that this idea of delegating what I've called the production of public goods is, there still could be rules that specify it, and especially, but going back to Andrew's question, in a way, when you say, well, corporation follows this purpose, which includes the well-being of the community, the respect of the environment, it gets, I think, fairly close to the idea that you are giving them the responsibility to take care of the wellness, of the welfare of the society at large. So I do understand it's, from my point, a little bit of a rhetorical trick, but I was curious to know from the economist perspective if there's some truth in that, if there's some potential issue or not.
You can't hear me?
No, yes.
No, very, very difficult question. I'm very thankful I'm not your student, because otherwise I would have zero. But from an economist point of view, I agree with you. We need enforcement, especially for business. But from an economist also, I do think that, as I said, I think that regulation alone, but still, for instance, I take into account the Tunisian case and the MENA region. We are still, far behind what we need in terms of regulation. Then it's really extremely lax environmental regulation, and we need to do more, and we need more pressure, actually. And specifically, again, that it is actually, as I told you, even from a policy point of view, it's not sustainable. It can't work because workers are not happy with this condition anymore. We are blocked somehow because people can't share or are not happy with the condition for their health and different perspective, the condition of their village, of their etc. Then there is a lot of margin here. There is a space to do on the regulatory level, either local or regional or international. Then I'm telling also, but from an economist point of view, there are other two things we can work on to them. Then the incentive mechanism, which is, I think, very important to put it to the side, financial mechanism, punishment, other things. And third, there is still a lot of things to do from an economist point of view. The tools we have as economists for the policymakers, also for the government, it's, tariff and non-tariff barriers. For the tariffs, for instance, a very recent paper from Shapiro, 2020, shows that actually the tariff distribution on low content environment, low polluting actually products are very high compared to tariff on high polluting products, then we can change at least these things, you know. But this is also for the US, for many countries. I'm sure it's the same for developing countries. Then we also can change distribution and the structure of tariff, and putting high tariff on high polluting products, on, you know, fossil using energy, whatever. And it is something we can do. And I think there is not enough consciousness about these debates, and we need to put light into them. This is my answer as an economist, very, very partial, but at least I try to answer you. Thank you.
Thank you very much. Do we have any other questions? Well, if not, we do not have any other questions.
May I pose a question?
Please, thank you.
Thanks. So I have two questions, one for Marco and one for Leila. So the first one for Marco is, so if you could, which would be the main, would you delete the directive? Would you propose any specific amendments which are the most urgent that should be voted within the project? And for Leila, do you, if you think that the inclusion of climate change obligations within trade agreements might work as a useful instrument to make the trade interact properly? And so what do you suggest from the economic point of view, whether they can interact properly?
Thanks, Angelica. It's I entirely scratched in the sense of not regulating this matter. I would make or suggest a lot of specific changes that basically, frankly, would be aimed at affirming and clarifying the principle that there might be a liability for certain violations that more often than not, but probably not always, would already or could already be considered either tort or a liability for the breach of some specific rules. But I think that's fair enough. I would, however, apart from a few technical things that I think are in urgent need of correction, just to give an example, there's a part that says, and I can't find it now, but basically says that mediations and agreements in that respect with affected party do not affect liability. And so if you take away that incentive, why should I, as a business, mediate and try to reach an agreement if that does not allow me to avoid other kind of litigation? Now, just to give an example, and there are, I think, at least 6 or 7 like that. I would clarify at the minimum that there could be also a liability for acts of third parties, but provided that the potential defendant was somehow in control. Had some kind of influence, either in terms of omission on the supplier, and so try to remove this from a kind of non-fault liability. And last but not least, probably I think it would be necessary for courts in Europe some kind of forum non-convenience possibility to dismiss litigation, which I believe not all European systems have something like in the US, probably few. But once again, you know, if you find yourself in a position where, you know, the evidence is abroad, what should our poor, already overwhelmed, structurally and tragically late and inefficient courts do? So I think that something like forum non-convenience, while very new and revolutionary, might be useful. And as the US experience teaches, it could also be used as a tool. So, for example, in the US, I understand we are in a different legal culture, but sometimes the court says, you know, we're not going to address this because of forum non-convenience, unless these things happen. And so it's kind of way to put the parties the burden of maybe adjusting some things, and if they don't, then the court will take the case.
Thank you. Can I just add a remark on the very last point, Andrew? Do you allow me? Your position on forum non-convenience, because I mean, I did not have the time in my presentation to stretch the fact that it was very much in favor of the introduction of forum necessitatis, which is exactly the opposite. So it's interesting to see that we use Latin to stretch exactly different and opposite concepts. And in fact, the treaty provides for the introduction of forum necessitatis. That was, again, one of the proposals that were deleted from the directive. I mean, from the proposal of the European Parliament. At the beginning, it was part of the proposal of the European Parliament and then deleted, while the treaty still provides for the obligation of the contracting states to include within their domestic system the forum necessitatis, because even though I see your point, I also see a very big point on the fact that there is a big risk of denials of justice when these transnational cases are at stake. And so there are victims who do not have access to justice, but not only to the natural judge, that is something, the right to a court. So the problem is that there are victims who do not have access to justice, neither in their host state nor in the home state. And that's why I would suggest, instead of including forum non-convenience, to include forum necessitatis. So it was interesting to have the chance to discuss about this point. Thanks.
Well, thank you very much. If there are no other questions, then
maybe Leila, there was a question.
Leila, I had posed it.
Yeah, then I'll actually thank you for your question. I will summarize then. Actually, from what we found, the actual USMCA and what we call NAFTA had good, empirically at least, quantitatively, fared better than other trade agreements without environmental regulation or provision, or at least not enforced environmental regulation. For instance, we compared with the European Euromed free trade agreement, and we found that the NAFTA fared better in terms of conversions of CO2 emission. Then at least this is an example, not perfect, but an example of provision that we can use. But from GVC, and it's also working on the GVC deal. And the GVC deal, again, what is important, it is the chain. The fact that actually if you don't, if you are not able to respect some standards, you are out from the value chain. And this is something, this is strong enforcement, actually, that could be used on GVC type of trade agreement. And I think Professor Mitchell, I saw some agreement based on the GVC agreement, for instance, between Australia and Indonesia, and they were working, and it was a business council before that they were thinking about what kind of GVC deal could work. And they were also looking to what kind of environmental provision that are sustainable, that they can implement and they can be dealt with at the business level. I don't have exactly in mind the type of regulation, but at least there are some thinking about that we should take into account seriously. Because otherwise, again, it will, looking always for efficiency, it will not work. At some point of time, it's not working. It cannot also work at the social level. For me, I even call it a social contract, actually. That is absolutely important to go forward. Again, then for as an economist, we should be able to measure also things in order to be accountable. Then if we have CO2 emission now at the country level, we also need to have CO2 emission or CO2 local content per product to know what we are talking about. We need to have environmental footprint. We need to be able to measure that at the firm level. This is actually, we are trying to do that. For instance, I am now working with World Bank surveys where they are trying to measure the environmental footprint of firms in value chain. This is some metrics that are useful to be accountable, to hold the company accountable, and also to be able in a GVC deal. This could be really important to take into account, to trace the suppliers, the other contractual firms that are in the chain. Again, from a trade agreement, it's important to put more, to increase, it's not protection, but really to have a positive discrimination, kind of, on products with low level of pollution, and put more pressure on products with high level of pollution. I think these are kind of things feasible, and it will put pressure on both types of country, and it will, of course, it will be translated at the firm level too.
Thanks.
Well, thank you very much. Well, I would like to thank all three of our panelists for fantastic presentations and very excellent responses to questions, and perfect time management that's taken us almost exactly to the dot. 8:30 p.m. my time, but much closer to lunch, I think, in Europe. And yes, I've certainly learnt a lot. And on behalf of the audience as well, I would like to thank you very much for your contributions. Thank you very much.
Thank you.
Thank you.
Thank you. Thank you very much.
Take care.
I'll
See you soon.
end this presentation. Thank you very much, everyone.